Honor, may I seek recognition of Honorable Juliana Ray Yan Ibay for her privileged speech.
Kinikilala ng hapag ang kagalang-galang kung siya Yan Ibay.
Maraming salamat po, Your Honor. I stand before this esteemed chamber today, both as a member and as an elected local official, to address a matter that I sincerely hope and pray will never happen to any of you in the future. I am referring to the obiter dictum made by our city legal officer regarding partisan political activities, which appears to be aimed specifically at me as an elected barangay official. The fact that I was singled out in this way has caused me great concern, instilling a sense of fear and raising serious worries about political harassment and the potential infringement on my political rights. Allow me to share a brief background on the matter. On September 20, 2024, I received an anonymous complaint letter coursed through the hotline 8888, endorsed by our city legal officer, directing the undersigned to respond within 72 hours from receipt. The response was submitted within the prescribed period. Among the hypothetical responses provided, assuming for the sake of argument, but without admitting anything, was the concern regarding a perceived violation of the political neutrality clause for elected Sangguniang Kabataan or SK officials, allegedly under Republic Act 7160 and or Republic Act 10742, I quote, "The allegations regarding the violation of political neutrality of the Sangguniang Kabataan nowhere in Republic Act 7160 or Republic Act 10742 does it mention any provision about it. Nonetheless, no political faction exists within the Sangguniang Kabataan Federation of Manila. Both the SK Federation and the Office of the Undersigned are continuously extending services to the youth of Manila in general and to SK officials specifically, regardless of any perceived biases as stated in the complaint." This portion of my reply led to another letter, this time from the city legal officer herself, dated October 28, 2024, which highlighted the first and last paragraphs, to wit, "We reply to your above-mentioned letter which states, the allegations about the violation of political neutrality of the Sangguniang Kabataan nowhere in Republic Act 7160 or Republic Act 10742 does it mention any provision about it." The city legal officer said, "It would be wise for you to be aware that this statement may be construed as an implied admission that you are involved in partisan politics. Therefore, we request that you do not place this office in a position where it will be compelled to exercise its mandate in light of the complaints and evidence that have been filed against you." In my response letter, particularly regarding the first paragraph, I clarified that the statement was merely based on the complaint. I assumed, for argument's sake, without admitting any violation, that certain activities might be considered as partisan politics, which, according to the city legal officer's letter, are not allowed for all barangay officials, as stated in Section 14 of the Joint COMELEC-CSC Advisory on Electioneering and Partisan Political Activity dated March 29, 2016. If such violations are committed, it would necessitate the city legal office to exercise its mandate. Consequently, all barangay officials who have participated or continue to participate in partisan politics, particularly during the filing of certificates of candidacy and other political activities, should also receive a letter from the city legal officer dissuading them from engaging in any political activities. In the absence of such a letter to all barangay officials in Manila, this could be construed as a form of curtailment of my constitutional rights and the case of political harassment. Citing the legal maxim, expressio unius est exclusio alterius, what the law does not include, it excludes. The existing prohibition on partisan political activities applies only to appointed and career government servants, as well as to military, police, and other paramilitary units, and does not apply to elected officials without any distinction between national and local officials. As stated in the following, the first being that of the 1987 Philippine Constitution, Section 2, Article 9B of the 1987 Constitution, and the implementing statutes apply only to civil servants holding apolitical offices. Stated differently, the constitutional ban does not cover elected officials. BP 881, the Omnibus Election Code, Section 261, Prohibited Acts. The following shall be guilty of an election offense. 1. Intervention of public officers and employees. Any officer or employee in the civil service, except those holding political offices, any officer, employee, or member of the Armed Forces of the Philippines, or any police force, special forces, home defense forces, barangay self-defense units, and all other paramilitary units that now exist or which may hereafter be organized who, directly or indirectly, intervenes in any election campaign or engages in any partisan political activity except to vote or preserve public order if he is a peace officer. Last is the Republic Act number 7160, the Local Government Code of 1991, Section 93, partisan political activity. No local official or employee in the career service shall engage directly or indirectly in any partisan political activity or take part in any election, initiative, referendum, plebiscite, or recall except to vote, nor shall he use his official authority or influence to cause the performance of any political activity by any person or body. He may, however, express his views on current issues or mention the names of certain candidates for public office whom he supports. Elective local officials may take part in partisan political and electoral activities, but it shall be unlawful for them to solicit contributions from their subordinates or subject these subordinates to any of the prohibited acts under the Omnibus Election Code. Assuming that Section 14 of the Joint COMELEC-CSC Advisory on Electioneering and Partisan Political Activity dated March 29, 2016, as cited in the City Legal Officer's letter, is legally binding, though it contradicts both statutes and the Philippine Constitution. This provision of the Joint Advisory was already overturned or overruled during the COMELEC's deliberation, as stated under Minute Resolution number 22-0198 entitled in the matter of the need for clarification of COMELEC-CSC Joint Circular number 001 series of 2016 dated March 2, 2022, the Commission and Bank resolved, among other things, to recommend that the elective barangay officials be exempt from the prohibition under 261 of the Omnibus Election Code. The pertinent provisions read, after due deliberation and considering the foregoing, the Commission resolved, as it hereby resolves, to approve the recommendation of the Law Department that elective barangay officials be accepted from the prohibition under 261 of the Omnibus Election Code without prejudice to the power of the supervision of the Department of Interior and Local Government over elective officials and to any administrative liability elective officials may incur under law other than Section 261 of the Omnibus Election Code. In conclusion, the last paragraph of the City Legal Officer's letter, cautioning the undersigned not to put their office in a position that would compel them to exercise their mandate, to my mind constitutes a form of political harassment. Once again, I hope and pray no other local elected official, whether a city or barangay official, will ever be subjected to such actions. And if so, send out a letter to the 14,336 elected barangay and XK officials in the City of Manila, the 27,360 elected barangay and SK officials in Metro Manila, and the 672,720 elected barangay and SK officials in the Philippines. Thank you very much, po, Your Honor.
Thank you. Majority Floor Leader.